Constitution should receive a liberal interpretation in favor of the citizen is especially true with respect to those provisions which were designed to safeguard the liberty and security of the citizen in regard to both person and property. Can you see that? Can you all see that? Is that coming out right here? Over more. Okay. All right. To safeguard the liberty and security of the citizen in regard to both person and property. See Note 31, Briars v. United States, 273 U.S. 28, and all of these 40 Supreme Court cases hold that axiom. In other words, it's supposed to be liberally enforced in favor of the citizen for the protection of rights and property. And a constitutional provision intended to confer a benefit should be liberally construed in favor of the clearly intended and expressly designated beneficiary. 32. Go down 32, DeJammer v. Hospital Authority of Albany, in all of these cases. Okay, can you see that? All right, help me out here. Okay, is it in? All right. I'm just trying to tell you. You can go look this up and you can better see it. Can you see it clearly now? Okay. All right, now, let's do that over again. And a constitutional provision intended to confer a benefit should be liberally construed in favor of the clearly intended and expressly designated beneficiary. Similarly, a provision intended to afford a remedy to those who have just claims should receive a beneficial construction for the purpose of extending the remedy to all who might fairly come within the meaning of the terms. And that's Ryder v. Fitchie of Ohio, a Supreme Court case, okay? That's note number 33. Okay? Now, this comes out of 16th Am jurisprudence. In other words, I have this Constitution. This Constitution is a contract in writing enforceable in the court of law pursuant to the statute of frauds. I'm asking for specific performance, Your Honor, in favor of me. I am the beneficiary of the contract. There's also a basic premise in contract law, Basic Contract Law 101 of any first-year law student, that says, the contract shall be enforced most favorably in favor of the non-preparer. And that's you. You didn't prepare it. Now, if you believe honestly that you have a right, and you can timely bring that right before a proper adjudicated authority, and you can clearly stipulate as to what your right was, guess what? They gots to listen. That's the way it is. That's the way it's supposed to be. And I'm telling you, if you know your rights and you timely assert those rights, you have those rights. But if you sit on your haunches and you cry foul, that's terrible. Somebody ought to do something about that. Hey, be a somebody. Do something about it. Don't sit there telling me somebody ought to do something about that. Be a somebody. You do something about it. You honestly got an honest bitch, you go out there and you take care of it. Because that's what it takes to be an American. That's what it's all about. That's what being an American is all about. That's what separates you from the rest of the whole world. Because Americans, you don't trample on their rights because they're going to come get you. You do not trample on their rights. They won't put up with it. So be an American and don't put up with it. Stand up there and be counted. Now I want to read the next argument there, which is argument number 98, which basically deals with the effect of an emergency. Argument 98. Does everybody see that there? Get it there? Pretty good? All right. Argument 98. While an emergency cannot create power, and no emergency justifies the violation of any of the provisions of the United States Constitution or state constitutions, public emergencies such as economic depression, all right? I'll go over here to the next page. What happened here? All right, let's go. For especially liberal construction of constitutional powers, and it has been declared that because of national exigency, it is the policy of the courts in times of national peril so liberally to construe the special powers vested in the chief executive as to sustain and effectuate the purpose thereof, and to that end also more liberally to construe the constituted division and classification of the powers of the coordinate branches of the government, and insofar as may not be clearly inconsistent with the Constitution, right? In other words, they can't be in conflict with the Constitution, to vest extraordinary powers in the chief executive. But I'm telling you, on the other hand, a contention that a grave emergency, such as the Depression, should permit construction of the constitutional provisions which would meet the emergency was rejected. In one case, the court holding that neither the legislature nor any executive or judicial officer may disregard the provisions of the Constitution in cases of an emergency. Where the plain and unequivocal terms of the Constitution present to question, of construction as to departures in emergencies. So not even an emergency justifies the taking away of constitutional provisions. And I know you've heard differently. I know you think, well, they got an emergency. They just declare an emergency and then the President issues an executive order. But let me ask you, if it's repugnant to the Constitution of the United States, is it law? No. Who says so? We do. We're the people. It's our country. It's our Constitution. We're the ones that say you can't do that. And we mean it. You better listen. All right, now, let's get into the next argument here. Now, I hope I'm not boring you to tears here, but it's kind of important that we cover these basic things so that you can understand. As to the construction with reference to the common law, an important canon of construction is that constitutions must be construed with reference to the common law. That means the law of the little people out there, not the corporations. Okay? Since in most respects the federal and state constitutions did not repudiate but cherished the established common law, this fact has been taken into consideration by the courts in construing certain clauses in a state constitution, such as the provision securing the right to a jury trial. Also, provisions in regard to crimes have been interpreted with reference to the common law rule that one charged with a crime may be convicted of a lesser offense necessarily included in the crime charged. In such cases, the courts of the state always regard the language in the common law sense. So the common law prevails. Don't let anybody tell you this admiralty law prevails, because it only prevails if you get sucked into it. We're not going to let you do that. We're going to teach you how to beat it. The common law also permitted destruction of the abatement of nuisances by summary proceedings. Traffic tickets, folks. That's what a traffic ticket does. It is a writ of assistance, a bill of attainder. It's unlawful in the United States of America. And it was never supposed that a constitutional provision was intended to interfere with this established principle. And although there is no common law of the United States in the sense, who said so? Erie Railroad versus Tompkins. Okay? Alright? Of a national customary law as distinguished from the common law of England, adopted in the several states. In interpreting the federal constitution, recourse may still be had to the aid of the common law of England. It has been said that without reference to this common law, the language of the federal constitution could not be understood. So the common law applies, folks. And we're going to get into that common law heavily in the advanced section, all right? Okay. Now let's get back into this. In interpreting the federal constitution adopted by the several states, all right, the recourse may still be had to the aid of the common law of England. It has been said that without reference to the common law, the language of the United States Constitution would not be understood. This is due to the fact that this instrument and the plan of government of the United States were founded on the common law as established in England at the time of the Revolution. Okay? Therefore, it is the general rule that the phrases in the Bill of Rights taken from the common law must be construed in reference to the latter. Specifically, the United States Supreme Court has taken the common law into consideration in construing the Fourth Amendment, the Fifth Amendment provisions relating. All right? So the common law is extremely important that we get in, and we will cover that thoroughly. It's important to understand that most of you out there are citizens at the common law. That only those that understand the differences in admiralty and maritime law, those that are corporations, officers of corporations, or officers of government residing in the District of Columbia, the 14th Amendment duality of citizenship, which is talked about in the case of Erie Railroad versus Tompkins, which is a rather heavy argument. And I will cover that thoroughly with you so that you understand where the traps and the differences are. But for right now, I'm trying to demonstrate to you construction and programming so that you can understand that this Constitution right here is the supreme law of the land. It is a contract in writing. It is enforceable in favor of you. In an open court of law, you are the beneficiary. Okay? I want to give you some basic more points on this Am Jurisprudence argument. This is section 114 of the 16th volume of Am Jurisprudence Second. I'm going to give you a couple more of these sites so that you can understand how powerful a document this is. Okay? Let's go to the next section, which is 115, which is let's see, which one? 117. 117 is the next serious section. They're all serious. By the way, I highly recommend you go down to the law library, grab that